Hi everyone, I'm Rhea Fawole and I'm the CEO and Principal Lawyer at SOLVi Migration, an Australian immigration law firm. Before I started SOLVi, I spent 20 years working inside the Australian government. 12 of those years was spent working in the Department of Home Affairs, so that's immigration. Part of the time I was in the Immigration Minister's office, I was in policy, program management, and also training visa decision makers. When I worked in the program management area, some of my work actually centered around simplifying the requirements for employers. And of course, so employers and recruiters have some things that they probably need to understand about sponsorship, how it actually works in practice under Australia's migration law. With all that in mind, I want to welcome you to Mind the Gap Australia. This podcast is here to give employers and recruiters clarity. I want you to understand what's actually happening in the Australian labour market and how sponsorship actually fits into a proper workforce strategy. Not just guessing, not just looking at what seems easy or instinctive, but having true clarity about how it all works. Today, we're going to be breaking down something that is fundamental. The actual legal steps that are going to be involved before you can sponsor someone from overseas. There are 3 separate stages and they have to be done in the correct order. So the first step is that we need to understand what does your business need to have in place, what the role needs to actually meet in order to be eligible to nominate someone for a visa, and then what the actual person must do to qualify for the visa. This is the order that Home Affairs basically needs to assess the case in order for your strategy to be successful in sponsoring someone. Now, before we get into all the detail, let me say what is most critical about how employers kind of misunderstand sponsorship. They aren't doing anything wrong. It's just that they haven't had the proper framework explained to them. They're relying on bits and pieces they've picked up from maybe candidates, maybe recruiters, or something that had worked once years ago under completely different immigration rules. And almost without exception, because people start in the wrong place, they look at the individual first. But when it comes to the legal process, it doesn't actually start with the individual person who needs the visa. It starts with your business. So let's begin with where the law begins. When you talk about sponsoring someone, the first thing is that the Department of Home Affairs needs to examine whether your business is actually eligible to take on that sponsorship responsibility. And this goes beyond the surface level of understanding that most people have. They're going to have to look at whether the business is genuinely operating lawfully and not just registered and holding an ABN, but it's actually trading. They're going to need to see the activity, the revenue, the staff being paid, the services being delivered. They're going to be looking for a functioning business, not just something that exists on paper. That's the first most important thing. They're also going to have to look into your workforce composition. They expect that most of your team are going to be people who are either Australian citizens or they already hold permanent residency in Australia. Having a temporary visa holder and stuff is perfectly fine and normal, but if almost everyone on your staff is on temporary visas, they want to understand why that is, and they need to look at whether or not the sponsorship program is being used properly in your business. The intention is to supplement, not completely replace domestic labour in the labour market. So they're going to be delving into this from a compliance perspective, and that's how the migration law is actually looking at. It's one of the first things they look at when they talk about adverse information. Adverse information can talk about whether or not your employees have actually been paid correctly, whether or not the super and the tax are up to date, whether or not you've previously sponsored and there was issues, fair work issues, other things that they need to take into consideration that potentially mean you can't effectively fulfill your sponsorship obligations. You don't need to be perfect. It's okay if there is a few things, but we need to be able to address and explain them upfront. Then there's the question of whether or not your business can actually support the role that you intend to sponsor. This has absolutely nothing to do with your business's size. Small businesses can and do sponsor all the time. It's about whether or not you actually have the operational and financial capacity to employ someone in that position full-time for at least 2 years. They also need to assess that you can do so at the correct salary level. In other words, does the position sit sensibly within your business structure? Now, all of this that I've just gone through sits underneath what we call a sponsorship vehicle, the legal vehicle that you're going to be using. Every business must be approved under the correct legal sponsorship framework before they can nominate and actually sponsor an individual for a visa. Most employers will start with something called a standard business sponsorship, which typically lasts for 5 years, unless you get accredited status. So higher net wealth and other sort of complex structures may look at getting accreditation, which is valid for 6 years. But depending on your location and the particular workforce needs that you have, there are other legal vehicles or instruments that could be required. For example, if you're in a regional area, it may be that you need to get a designated area migration agreement, which exists because the region has documented skill shortages and they need to access additional occupations or certain concessions. For some employers, typically those in certain industries or those delivering a major project, it may be relevant to consider another type of maybe industry-specific labor agreement or a company-specific labor agreement, or even a project labor agreement. So there's all these different kinds of sponsorship vehicles that exist, and we need to understand a bit more about which particular workforce challenges your business is trying to deal with in sponsoring people. The most common thread, I guess, across all of these is very simple. Before you sponsor someone, you have to be approved under the right sponsorship framework that matches your business needs. Sometimes it can mean setting up one approval. Sometimes it can mean setting up a number of different sponsorship frameworks. It really depends on your operational need. Once those approvals are in place, sponsorship becomes the back office kind of system that runs in the background for many years, because most of the frameworks last, as I mentioned before, 5 years. You don't need to redo them every single time you need to sponsor someone. So once you've got the correct sponsorship vehicle in place, then it's time to move on to the next step. The next legal step is called the nomination. So once you've got that correct sponsorship approval framework in place, whether it's the standard business sponsorship or some form of labor agreement, the next legal step that needs to be taken in every single time you want to sponsor someone is a nomination application. The nomination is all about the role, not really the person. This is where the department asks a number of very specific things around that particular role that needs to be fulfilled. One, what is the actual job? Where does it sit in your business? Does it meet the program requirements, meaning the migration program requirements? And is there a genuine reason why you need to sponsor someone from overseas for this particular position? What they really want to understand is whether the position is genuine and that it's an ongoing role, not just something that was created purely to help someone stay in Australia. The duties and responsibilities need to make sense for what your business actually does. They want to see if this job would exist regardless of who occupies it, really. Then they're also going to consider the salary that you're offering. This part is definitely not guesswork. Part of our job as your lawyers is to prepare a submission that demonstrates that the particular salary that you've got for the occupation and role that you want is lawful and appropriate for the role. So sometimes that can mean fair work, or on top of that, we need to look across the board at what the industry standard is. And we'll also look at things like enterprise agreements, industrial norms, and other employees in similar roles in your organization. They want to show that there is consistency with what is being offered as well as compliance. Before the nomination can proceed, labour market testing also needs to be undertaken in most cases. And what that will mean is, advertising nationally. But what I tend to see is people said, we advertised and we couldn't find anyone. There's a very legally prescribed process that needs to be followed. It's not just about putting one ad up on, an industry specific publication. It needs to meet the migration requirements and thresholds, and it needs to run for a specified period of time, needs to have certain content that is written in for the whole entire publication of that ad as well. We can't actually fast track that process, and you can't just fix that retrospectively. So that's why planning ahead actually really matters. Finally, the department is going to be looking at the employment contract itself. And this is where having a lawyer can be very helpful, because we can also look at the employment law aspects, which is going to be extremely important because the contract needs to comply with both employment law as well as the migration laws. Just so you're aware, a migration agent can't advise on employment law. They can certainly have a look at it from a migration law perspective, whereas a lawyer can fulfill both of these to identify clauses that may cause problems in terms of unfair terms, outdated clauses, or inconsistencies between the contract and the nomination, or terms that simply don't meet the Australian workplace standards. If the contract isn't right, the nomination can, and often does, fall over, even if everything else looks absolutely perfect. The last step is the one that employers often assume is the first one that they start asking about, whether or not the individual can actually meet the visa requirements. This is where some legal complexity can really show itself, because a proper legal assessment isn't just about reading someone's CV or taking someone's word for it, or, trying someone out who's been in your organization temporarily for a while on a temporary visa and I not really like them, they fit in well. You need to actually understand whether or not their qualifications in detail, and the name of the degree, the diploma, what's behind the academic transcripts and everything, how it aligns with Australia's qualification framework. The Australia's qualification framework is very precise, and we actually take care of evaluating whether or not what they studied is going to match the particular occupation that they're required to work in. And often there's another step which is called a skill assessment, depending on the specific occupation that you're sponsoring, and we'll need to get their skills assessed. So we'll need to know if it's going to meet the authority's requirements. That's an entirely separate process, and of course that all needs to have been done before the visa application gets submitted. It's not something that an employer could or should ever try to guess at. It is complex, and skill assessments can actually take quite a number of months to complete. We then need to look at English language requirements. Now, some people may meet exemptions, but don't mistake and assume that they do simply because they're from an English-speaking country, because a lot of this is going to depend on the professional requirements of the particular occupation that they're coming in for. So these are going to be really important, that they need to have those levels that are tested and meet the requirements before the application is submitted. We'll also need to look into background things like character, health, and that will include for their dependents. So if they've got a spouse or children, we're going to need to do backgrounds on all of those, because a dependent family member, particularly health issues or some kind of complex family situation that you aren't necessarily going to be aware of as an employer, it doesn't mean they can't be sponsored, but it can impact the visa, and it may impact which visas we say that they're actually eligible to be sponsored for. So as you can understand, all of these things need to be identified early. So when I hear people say to me, no, we'll get in touch with you if we need your help, that to me says we're not actually going to be prepared, and they often want a rush job. And you could hear from what I've explained today, it's not a process that we can just jump through loops quickly. There's a number of things that have to go into this rigorous process in order to get your amazing person in on the ground doing the work that is much needed. Now remember, they can't sponsor themselves. They can't just go and lodge a nomination either. Only the business can, and they can't advise you on which visa is actually going to be appropriate. They may think they can, but really it needs to come from someone who has the professional skills to see that that is correct. They're simply not going to have that same capability to really understand and keep your organization protected in terms of you looking in to sponsor them. As an employer, you need the right legal advice so that you know what the pathways are and whether or not they're viable, and which aren't long before a commitment or making any promises to sponsor someone. So let's do a quick recap. The sponsorship starts with your business, lawful operation, compliance, stability, and approval under the correct type of sponsorship framework. And that could be a standard business sponsorship or one of the labour agreements. We then look at the role. We need to see that the job is genuine and whether the salary is lawful, appropriate, and whether labour market testing has been done correctly, or we need to run it for you in the correct manner, and whether or not the employment contract is going to meet both migration and employment law requirements. After those processes, then and only then is when the actual person who you want to sponsor is able to lodge that visa application. So it's really important that in advance, you already understand whether or not they're going to meet the requirements, whether their qualifications, English, health for them, character for them and their family members is actually going to meet the migration requirements. This and understanding all of this work in advance is going to make sponsorship more predictable and workable. Just remember, if you get any of the order wrong, unfortunately, the whole thing doesn't quite work. So if today's episode made you realize that your current hiring approach isn't actually going to allow you to fill your shortages with sponsorship when you need to take some steps so that you don't get stuck later on. The next first step is to actually get clarity whether or not sponsorship is actually going to be the right option for your business, and to get in place things ready so that when you do know you want to sponsor someone, you are ready to go. We've actually created a 60-second business eligibility checklist. I'm going to pop that into the show notes. It's very simple. It's an online check, and it helps you to understand whether or not your business may qualify for sponsoring skilled overseas workers. If that's the case and you want to jump on a discovery call with me after that, go ahead and book. Or if you've got a case right now that you actually need that professional legal support and advice, please do go ahead and book a consultation on our website. That's www.solvi.com.au. Please stop guessing until the next time. Make sure that you get ready. Make a decision that is based on, fact and what's actually going to be possible for your business. I'm Rhea Fawole, CEO and Principal Lawyer at SOLVi Migration. Thank you so much for listening. I do look forward to seeing you in the next time. Please do like, subscribe and share. And I look forward to seeing you on the next episode of Mind the Gap Australia.